under seal in the case appropriately as it pertains to information relating to some argument on individual grand jurors whose identifying information is to be kept confidential under the rule. However, this court will conduct the hearing today with an instruction to counsel, which we will do in a separate breakout room on the record, but outside of the court's view or of the public view, to discuss the parameters of what I think should be argued in public or not throughout this hearing. Procedurally, going through how we got here, I'll note there was a motion to dismiss, initially styled as a 12B motion, filed on June 21st of 2021. There was an extension requested for that, which the court granted. That deadline was extended to September of last year, 2021. There was a renewed motion filed September 2nd. There were some objections filed by the state on November 8th to the continuance of the motion. There was a second renewed motion to dismiss filed on December 8th. And then the court issued an order on February 4th stating that there would be this hearing held today on March 23rd. Indicated that a memorandum in support needed to be filed no later than March 9th. Mr. Pryor timely filed his memorandum on March 8th as part of the motion. And authority to be submitted determined at the conclusion of the hearing by the state. So with that in mind and procedural history, we will go forward on the motion today brought by the defendant to dismiss the indictment. At this time then, I do want to first call a breakout room, which is essentially a sidebar in the virtual world here on Zoom. And in that breakout room, I'm going to discuss with counsel the scope of what I think ought to be referenced in the public purview versus what needs to be kept confidential under the rule for grand juror secrecy. So at this time, Madam Clerk, if you would please arrange for the breakout room, we'll go in there and discuss that issue, then we'll come back and commence with argument on the motion.
And you should all be able to join that room.
All right, appears we're ready to go back on the record here. Is the court reporter ready?
Yes, Judge.
Okay, thank you. All right, Mr. Pryor, as I previously mentioned, then you have filed a motion that was briefed and extensively briefed, and the court appreciates that. That was done on March 8th that you submitted that. So if you'd like to offer argument in support of your motion at this time, you may.
And Judge, I think I had indicated at the last hearing on the 17th that my argument was going to be very brief. I provided a memorandum with the court, a briefing of approximately 55 pages on this issue of the motion to dismiss regarding the grand jury impaneling. There were two accompanying briefs that relate to that motion to dismiss that I'd like the court to also consider as they relate to the grand jury proceedings. But Judge, in general, the motion to dismiss is based on the under Rule 6.6 of the Idaho Criminal Rules as it relates to impaneling a fair and impartial grand jury. I I have, I think, in significant detail, set forth my reasons for that. I have no intention, obviously, of disclosing the specifics of what I find objectionable. That's laid out in my brief. I'd ask the court to take that into consideration. But Judge, in terms of themes, there's been pervasive media coverage. That plays into the fairness and impartiality of the grand jury proceedings. The prosecuting attorney in this case chose to utilize the grand jury proceeding. I did not choose to do that. They chose to do that. They could have just as easily impaneled a preliminary hearing and chose to go that route. So the decision to use a grand jury was solely on the state. They have an obligation and a duty to impanel a fair and impartial grand jury. It's my position that that was not done. It's my position that the grand jury was, at least in some ways, impartial, or was not partial, was not impartial and was not unbiased. I've laid that out in my brief. The other issue, Judge, is this, is that the potential sentence in this case is death. The severity of this case, and this court addressed that in a prior decision that you set forth, and I believe that was in your memorandum regarding the venue. And you cited that death is different. And the magnitude of the charge, Judge, is what's important here. And when you're considering the validity or the impartiality of a grand jury proceeding, Judge, you have to take into consideration the consequence as a result of that. So there needs to be a higher scrutiny and a higher review of the standards that are set forth. And given that, Judge, I implore the court to look at what I have laid out in my brief and strongly consider that, at least from my perspective, this was not an impartial presentation before this grand jury. I'm asking the court to take as part of this the complete record of the grand jury proceedings. I'm asking the court to incorporate my brief and memorandum filed on the 8th and the 2 accompanying briefs as they only relate to the grand jury proceedings, Judge. But I think that if you take the opportunity to review my extensive briefing, I would ask the court to dismiss this indictment on that basis. And thank you, Your Honor. I will now defer to Ms. Blake.
All right, thank you, Mr. Pryor. Ms. Blake, what's the state's response on the motion?
I need to unmute first. Thank you, Your Honor. First of all, the state would indicate, as the court had mentioned at the outset of these proceedings, the state has not had an opportunity to get our brief submitted to the court. At the time that this hearing was set, I believe Mr. Pryor was given approximately 30 days, give or take, to submit a brief. We do recognize that Mr. Pryor absolutely timely filed that brief. He actually filed it a day in advance of the due date. Unfortunately, though, we hadn't looked at the timing of that very closely, and it left the state with only 2 weeks and 1 day from the time we got it to this hearing today. So in order for the state to have actually put a brief together and given Mr. Pryor ample opportunity to review that, that was why the state had originally asked for a continuance. As the court indicated, you had authorized that the parties could seek to supplement any argument with briefing. We would indicate to the court we've been working diligently on a brief, and we would intend to supplement the argument today with that brief. I'm not sure if the court wants to set a timeline on that, when that would be due.
I would like to set a timeline. If you've had a couple of weeks now to work on it, could that be submitted within 2 weeks?
Absolutely, Your Honor. And our hope is that we will actually have it submitted by the beginning of next week, but we will continue to work diligently on getting that put together.
Okay, just to be clear then, let's indicate that your brief will be due no later than Wednesday, April 6th at 5:00 p.m.
And Your Honor, the state does recognize that this is defense's motion. I do not know if Mr. Pryor then wants an opportunity to provide any reply or if he wants to look at it at that time. If he does, I don't know if we also want to set a deadline for any reply brief, whether that be from that April 6th date or just from the filing date that the state actually submits our supplemental briefing.
All right, Mr. Pryor, my inclination on that would be if you want to submit a rebuttal brief to their response, could you have that due a week later on April 13th?
Judge, would it be possible to give me an additional 7 days to the 20th? I anticipate a lengthy response from the state, and I want to make sure I'm sorry about it.
Okay, we can do that. So April 20th for any rebuttal or responsive brief filed by the defense, 5:00 p.m. will be your deadline for that, Mr. Pryor. Okay, Ms. Blake, then if you want to continue with the substance of your argument.
Thank you, Your Honor. In looking specifically at the grand jury proceedings, there are several rules and statutes in Idaho which are directly applicable and govern those procedures, requirements, duties, and remedies in relation to grand juries. Those are Idaho Criminal Rule 6 through 6.8 and Idaho Code Title 10, Chapters 10 through 16. So in large part, those are what the statutes and rules that the state is going to focus on today. Specifically turning to Idaho Criminal Rule 6.6, that specifically provides the grounds on which a motion to dismiss the indictment may be granted, and it lays out very specific grounds. Again, to not belabor the point, I think only a few of those are what was focused on by the defendant. And actually really the second one, that a valid challenge to an individual juror who served on the grand jury that found the indictment, except that finding of the valid challenge to one or more members of the grand jury is not grounds for dismissal of the indictment if there are 12 or more qualified jurors concurring in the finding of the indictment. Then when we turn to the Idaho Code, looking at the first section, 19-1001, it lays out that the people or person held to answer a charge for a public offense may challenge the panel of a grand jury or an individual juror. Idaho Code 19-1002 outlines the very specific grounds for challenge to a panel. And then when we turn to Idaho Code 19-1003, that's where we get the outline for the grounds that are allowed to challenge an individual juror that served on a grand jury. Again, there are several challenges laid out, and I think the focus of the defense has been on subsection 6 and 7 regarding 6, that he has formed or expressed an unqualified opinion or belief that the defendant is guilty or not guilty of the offense charged, but a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand juror or be cause of challenge. And then 7, that a state of mind exists on his part in reference to the case or to either party, which satisfies the court that he cannot act impartially and without prejudice to the substantial rights of the party challenging. Idaho Code 19-1601 also lays out the grounds for setting aside an indictment and includes very specific reasons for which a challenge or an indictment could be set aside. And again, not belaboring those, there are 4 different challenges laid out. And looking at number 4, when the defendant has not been held to answer before the finding of the indictment on any ground which would have been ground for challenge, either to the panel or to any individual grand juror. So what we can see is between the criminal rules and the statutes, there is some overlap when we're looking at challenges to an indictment. And one of the common themes that comes up is a challenge to the individual grand juror or the panel of the grand jury. And that's really been the focus at this point in time on the defense's request to dismiss the indictment. Looking at State v. Edmondson, 113 Idaho 230, specifically provides the grand jury is an accusing body and not a trial court. Its functions are investigative and charging. Goes on to say the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day, as long as the grand jury has received legally sufficient evidence which in and of itself supports a finding of probable cause. In addition, in Edmondson, the court provided, we note that dismissal is a drastic remedy and should be exercised only in extreme and outrageous situations, and therefore the defendant has a heavy burden. So in these situations with a motion to dismiss or set aside an indictment, the burden is on the defendant, and the courts have found that it absolutely is a heavy burden and that an actual dismissal of an indictment is an extreme remedy. And one of the things that is touched on briefly or is brought up in by the defendant is an allegation of prosecutorial misconduct. While the state takes the position that there absolutely was no prosecutorial misconduct, and that'll be outlined more clearly in our brief, but if legally sufficient evidence was presented, the indictment must be dismissed if prosecutorial misconduct in submitting illegal evidence was so egregious as to have a prejudicial effect on the proceeding. And that comes from State v. Forbes, and that's an unpublished opinion, 2020 IDA APP Lexus 352 and 2020 WL 5361067, and that is citing to State v. Martinez 125 Idaho 445.
And on that initial first site, what was the name of the party there, or the defendant in that first part of the site?
It is State v. Forbes, Forbes.
Okay, thank you.
And that case specifically cites to Martinez. It also cites to State v. Brandstetter. In State v. Brandstetter, the citation is 127 Idaho 885. And that citation deals with the court accepting that in making a determination, every legitimate inference that may be drawn from the evidence must be drawn in favor of the indictment. Oftentimes what we see with case law is the evidence or any inference is oftentimes drawn in favor of the defendant. However, when dealing with an indictment, Forbes references it, and Brandstetter also sets out that legitimate inference should be drawn in favor of the indictment. The state recognizes that those specific cases were dealing with whether or not appropriate evidence was admitted or whether any inadmissible evidence was presented to the grand jury. And what we see repeatedly with courts' analysis regarding that specific issue is so long, even if there is inadmissible evidence submitted, so long as there's enough evidence striking the inadmissible evidence, the indictment will stand. And that case talks specifically about the prosecutorial misconduct as well, that even if it's alleged, it has to be egregious. And not only does it have to be egregious, but the defendant needs to establish that based on that misconduct, he suffered some form of prejudice. And again, that burden remains on the defendant to establish that, not the state to establish it didn't happen. But again, the state's position is there was no prosecutorial misconduct. Then looking at a case from the Ninth Circuit, Silverthorne v. United States, that's 400 F2D 627. It also outlines that the grand jury deliberates and indicts as an accusing body on the standard of reasonable probability that a crime has been committed by some person. It is not a trial body. The quantum of evidence necessary to indict is not as great as that necessary to convict. If a grand jury is prejudiced by outside sources, when in fact there is insufficient evidence to indict, the greatest safeguard to the liberty of the accused is the petit jury and the rules governing its determination of a defendant's guilt or innocence. And if impartiality among the petit jurors is wanting, the cure is reversal by the appellate courts. And I cite to that case because throughout the defendant's brief, initially the Idaho code and criminal rules that were cited to by the state or cited to by the defendant. However, as the argument continues forward, most of the case law cited deals specifically with impartiality or actual or impartial or implied bias on the part of jurors that were sitting on a petit or a trial jury rather than a grand jury. And I'm unaware of any case law or other statute or rule that would make the same analysis applicable to the grand jury. And what we see in Silverthorne is the distinction between a petit and a grand jury, and that oftentimes the petit jury actually hearing the case is the safeguard and may even be the remedy, even if there is found to be any defect with regard to an indictment or how the indictment came about. Idaho Criminal Rule 6C provides in part that the district judge is the one that is in charge of impaneling a grand jury, and that district judge also has the opportunity to inquire of the prospective grand jurors and to determine whether or not they are qualified to serve. It goes on to lay out that specifically there are two things that the court looks to determine if they're unqualified to sit as a grand jury. And one of those is Idaho Code 19-1003, which again outlines the specific standard applied when looking at whether or not a grand juror was improper to be seated. And again, indicating that is a different standard than what is applied to a grand juror that may not be seated, or that a challenge may be made, or what challenges may be made if they are sat on a trial jury or a petit jury. And those are Idaho Code 19-2020. They do allow for different challenges jurors, again, focusing back on the heightened burden that a jury trial is actually tasked with. And Idaho Criminal Rule 6.1b is that's the rule that provides in part that the prosecuting attorney has the power and duty to also investigate and inquire whether or not there are grounds for disqualification of any grand juror, and advise the presiding juror of the possible disqualification of a juror. So the voir dire process through grand jury proceedings is very different than through the trial proceedings. There actually is no inherent right under the Idaho criminal rules that the prosecuting attorney even has the opportunity to conduct voir dire. In this situation, the prosecuting attorney did have that opportunity, but it is not specifically the prosecuting attorney has the right or the duty at the commencement of the presentation of an investigation. And that's in large part because a grand jury may sit and hear multiple cases, and each case may be different. A grand juror may have a disqualification for one case that may be presented to them or for certain evidence, but be able to sit for other cases and other evidence.
All right, Ms. Blay, and I think that's kind of an important point to consider. So you're indicating that because clearly in a trial with petit jurors, you've got a vetting of those jurors through the voir dire process conducted by both sides. In a grand jury proceeding, obviously the defense is not present, and there still needs to be some sort of gatekeeper function to make sure you have fair and unbiased jurors that sit as grand jurors. And so you're saying that under Idaho Code 19-1003, there's a different standard applied to challenging grand jurors, or we wouldn't call it voir dire because it's not really that, but to essentially vetting out those jurors that may not be qualified?
Yes, Your Honor. When you look at those specific rules, they actually outline different reasons for which a challenge can be made to a juror. So 19-1003 has 7 possible challenges that are outlined, which can be brought to challenge an individual juror. Specifically, there is some reference in the defendant's brief to the grounds for challenge under 19-2020, which actually lay out the challenges for a petit or a trial jury, where the challenges allowed are different. And from what the state can discern from looking through case law, it appears that a large part of that differentiation is that the grand jurors, again, are just an investigative body and they're only making a probable cause determination. They're not making a finding of guilt beyond a reasonable doubt. They're not stuck with that paramount decision that is made by an actual petit or trial jury. We can find no case law to support that the same standards would be applicable to the seating of a grand jury. And I think the statutes actually tend to clear up that issue because they are separated out and those challenges are different.
Okay, I appreciate the response. And so to summarize, you'd say essentially it's a lower standard for seating a petit juror versus a trial juror?
Yes, when you look at what the challenges are laid out, it does appear to be that there is a lesser standard because there are other remedies available short of just dismissal or setting aside a verdict if that's where it ended up with a petit jury or a trial jury. Whereas with the grand jury, there are some other remedies available. And again, one of the remedies highlighted in several cases is the ultimate remedy to cure a defect if the court, unless the court determines an additional remedy is necessary, would be to actually have all of the evidence heard before a petit jury that is impartial and making that final determination.
Okay, thanks for those responses. You can continue.
Thank you. And again, the state doesn't want to get too much into some of the specifics, recognizing that the grand jury is a sealed proceeding, but I would mention that from the state's review of things, and again, this will be discussed more in depth in our brief, but from a review of the transcript from the grand jury proceedings, the state's view on that is the court did repeatedly ask follow-up questions, at times to group and at times to individuals who raised their hands in response to a question. And oftentimes those questions dealt with the juror's ability to remain open-minded, fair, and impartial. The state did the same, because again, while the state can't find a rule on point, absolutely giving the state the opportunity to conduct voir dire, we were allowed to conduct it in regard to seating the grand jury. So it is the state's position that both the district court and the state did conduct proper voir dire and did follow up where necessary to ensure that an impartial and unbiased grand jury was in fact seated. Also, and in State v. Dunlap, the court dealt specifically with voir dire in capital cases, and State v. Dunlap is 155 Idaho 345, and it states, while there is no absolute constitutional right to individual voir dire in capital cases, the method of voir dire must comport with due process requirements. So again, that case is actually dealing with the seating of a petit jury versus a grand jury, but it indicates that there is actually no heightened right in a capital case over another case, but that it simply should comport with the due process requirements as any other criminal case should. I think there is some argument, and again, the state will be brief on this because I think it goes into some of the grand jury proceedings, but there is an argument raised regarding the potential of jurors having a relationship with a party or a witness. And the case on point is that the state has found would be State v. Buhanda Velasquez, and that is 129 Idaho 726. And in that case, they did specifically analyze relationships between grand jurors and the prosecuting attorney and whether or not there actually existed a relationship. And that case also cites to a couple other cases where the same analysis was conducted to determine whether or not a relationship between a juror and an attorney would be a basis for disqualification. In State v. Cipher, 92 Idaho 159, the court upheld the trial court's denial of a challenge for cause of a prospective juror who was, at the time of trial, employed by the prosecuting attorney's firm as a janitor. The court held that such a prescribed relationship must be shown to exist between the juror and accused, or the person allegedly injured by the offense charged. And then also State v. Major 105 Idaho 4, the court cited to Cipher and held that a relationship between a prospective juror who was a county treasurer and the prosecuting attorney was not that of attorney-client and thus did not suffice to disqualify the juror. And then in State v. Bohonda Velazquez, the court determined as well that there was no impropriety in a juror being sat where the defense alleged that that juror had failed to disclose during voir dire a close and/or business relationship with two prosecutors, one who presented to the grand jury and one who just worked in the office. They ultimately, the Idaho Supreme Court ultimately determined that the proper standard was applied in denying the motion to dismiss because there was no actual evidence to support a relationship between the defendant, with the defendant or the prosecuting attorney, and that it was not such that would have affected that juror's ability to be seated. Again, there are specifics that the state will simply provide in their brief. There are several arguments made by the defendant with regard to individual jurors, and the state believes that all of those jurors were appropriately seated and that they wouldn't need to have been removed. And again, when we look back at the rule, even if the court did find any merit in any of the defendant's arguments, so long as there remain 12 jurors that return a unanimous indictment, the indictment would stand. And again, I just highlight that throughout the briefing, Idaho Code 19-2020 is referenced when arguing challenges to specific grand jurors. But again, the applicable section is Idaho Code 19-1003. However, I would indicate the state's position is even if Idaho Code 19-2020 were applicable to grand jury proceedings, it is the state's position that the grand jurors are still proper and qualified and grand jurors. And again, that will be briefed, more fully briefed. And sorry, Judge, I'm just going over some stuff that I do not think would be appropriate to put on the public record at this time. One of the other arguments raised is that there is an incomplete record of the grand jury proceedings. Idaho Criminal Rule 6.2a provides all proceedings of the grand jury except deliberations must be recorded either stenographically or electronically. The defendant alleges the recordings were stopped at times. And the state would indicate that we believe the proceedings were properly recorded, that there is no rule or statute, again, that the state can locate, which would indicate that a recording should continue to be played if the prosecutors are conducting any kind of sidebar amongst themselves and or if the parties are entering into a break. The defendant cites to Dustin v. Superior Court, which citation is 99 Cal APP 4th 1311 as a grounds to have an indictment dismissed based on the recording not being complete. The state would specifically distinguish that case from the case in front of this court. In Dustin v. Superior Court, the real concern was the prosecuting attorney had actually requested or instructed, the court reporter to leave during both the prosecutor's opening and closing statements to the grand jury. The court in that case essentially determined it would be difficult to imagine an innocent reason for the court reporter to be instructed to leave during the prosecutor's comments, except for that the prosecutor didn't want those to be reviewed later. And even in that situation, and that case also was a little different in the sense that they were looking specifically to the fact that it was a capital case. And so capital cases should be conducted on the record. California did not have a specific rule with regard to the recording of the grand jury proceedings. Idaho does require those proceedings be recorded. The state also recognizes the law regarding capital cases, and it is the state's position that those were properly recorded. The defendant has had an opportunity to look over those transcripts and has clearly raised some allegations based on his review of that transcript. And then looking at Idaho Code 19-1605, it provides that even if an indictment is set aside under these grounds, specifically referring to the above statutes, so with the challenges to the impanelment or the individual grand jurors or the other grounds which would allow for review of an indictment and for it to be set aside, it is not a bar to a future prosecution. In addition, when we look at Idaho Criminal Rule 48, which deals with dismissals, it indicates that a court may, on notice to all parties, dismiss the criminal action on its own motion or motion of either party, and it provides the grounds, and that includes for any other reason if the court concludes that dismissal will serve the ends of justice. But an order for dismissal is not a bar to a subsequent prosecution for the same felony offense. It would bar a prosecution for the same offense if it were a misdemeanor, but not if it is a felony. And then in a federal district court, specifically the court for the District of the Virgin Islands, in a recent decision, U.S. v. Benjamin, 2019 U.S. Dist, so D-I-S-T, Lexus 173202, and 2019 WL 4920875, also looked at the remedies and provide, consistent with the impracticality of other remedies concept embodied in both structural and harmless error analysis, the Supreme Court has recognized that defects in criminal proceedings, including those implicating constitutional rights, do not necessarily warrant the ultimate remedy of dismissal of an indictment, let alone dismissal with prejudice, where remedies short of dismissal are available. And that case cites to United States v. Morrison and adopts their language. So again, just in conclusion, it is the state's position that there are no grounds that have been established by the defendant which would support the finding that the indictment needs to be set aside. And that even if the court were to find any grounds to set aside the indictment, complete dismissal and or precluding the state from proceeding forward with another indictment would not be supported by the findings of other cases that have reviewed situations of this nature. And then again, that the defendant does in fact have the burden, and that burden should be established under the appropriate standards set forth by the Idaho legislature and in the Idaho criminal rules. And the state has outlined those today. They will be, again, more fully outlined in our brief. And we would reiterate our request to just submit that supplemental briefing. The state has already granted that, but we will get that submitted as soon as we can so that the court has that for review. Lastly, I do want to touch on this actually, reiterating.
I do have a follow-up question on the issue. You've argued on the sufficiency of the record, and it's a pretty specific question. There's a part of Mr. Pryor's briefing where, and I'll just reference you to that, and it's on page 10, where he indicates that the defense should be entitled to not just the role of juror numbers on the voting roll, jurors identified only by number, but that those particular jurors and their votes should be identified by name also. Does the state believe that is part of the record that the defense is entitled to in the jury voting rolls?
Your Honor, I think my recollection is what the rule outlines, and I believe I don't have it right in front of me, but I believe it's outlined in the Idaho criminal rules that provides that a defendant can have an opportunity to review the voting sheets. In addition, there's a rule that outlines that at the conclusion of any grand jury proceedings, prior to an indictment either being found or not found, that the voting list should be placed into a sealed envelope. At the outset, grand jurors are assigned specific numbers, and so the voting sheet, it's my understanding, contains those individual numbers. Those numbers are assigned to a specific grand juror. I do believe the defense, I will say it this way, actually, I'm unaware of anything that would specifically allow or specifically prohibit the defense from obtaining the names associated with those juror numbers. Because the state would have had the benefit of knowing which juror number was assigned to which juror, it would follow practical reasoning to the state that the defense could make that request and would be authorized and allowed to review that information as part of the entirety of the record. So the state does recognize the voting sheet would not have contained that, but I'm unaware of anything that prohibits the defense from asking for that or that would prohibit the court from granting it. And again, because the state has that knowledge, it would seem that the defendant should be allowed to review that information as well.
Okay, well, I appreciate the response on that issue.
And then the last point I just wanted to touch on again was looking at that Idaho Code 1003 with regard to a challenge to an individual juror. I would just reiterate specifically that a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand juror. I think there were some challenges raised based on pretrial publicity. Mr. Pryor touched on that briefly today, and I know it was covered more in depth in his brief, but I think without more of a showing than simply a statement that there was pretrial publicity, and because a juror had viewed that must affect their ability to sit as an impartial juror, is clearly, I think that situation was somewhat anticipated by the writing of that rule. Not this specific situation, but that a situation would arise in which a juror would have heard some outside information or seen some kind of news coverage, but so long as they can set that aside, and I think that is covered. So I would just reiterate that because I think that was one of the other main points raised by the defense in their brief. Again, we'll more fully brief this, especially where we can get a little more into the specifics of this without violating any kind of grand jury process. We'll cover that more specifically in our brief.
All right, thank you, Ms. Blake. So does that conclude the state's argument, Ms. Blake?
That does, Your Honor, unless the court has any additional questions.
Okay, thank you. Mr. Pryor, would you like to offer a rebuttal argument?
Very briefly, Judge. I noted, Judge, that at least a significant portion of Ms. Blake's argument centered around the evidence that was presented to the grand jury. If the court looks at my brief, the vast majority of my argument, Judge, is the fairness and impartiality of the grand jury itself. And I'm going to rest on the evidence, and the evidence is the wrong word, Judge. I'm going to rest on the contents of my brief in terms of what I presented to the court and the attached references to the transcript itself. I do want to touch on something, Judge, in terms of the incomplete record. Ms. Blake and Mr. Wood and Ms. Smith do not get to decide what portion of the grand jury proceedings I get and what portion I have to specifically request. That's not the way the rule works, and it's somewhat concerning to me that Ms. Blake would suggest to the court that Mr. Pryor at any time could make a request for additional information. That's not the way it works, Judge. Mr. Daybell is entitled to the complete record of the grand jury proceedings. Now, I brought that issue up, and I've referenced where I feel that there has not been a complete record provided to me. And I brought up a couple of instances where that I believe, at least strongly believe, that's the case. But again, Judge, I'm entitled to that information, and it's not a matter of me requesting additional information or requesting supplement or just requesting information that this prosecutor has access to. If the suggestion from Ms. Blake is that, Judge, if I want to challenge any specific juror for cause, you'll need to request that information to find out who they are so that you'll have an opportunity to do that. That's not the way it works, Judge. That's absolutely contradictory to what the rule is set out and the way this thing is supposed to work.
Which rule specifically are you referring to, Mr. Pryor?
Well, Judge, Rule 6.6 of the Idaho Criminal Rules allows me to challenge any juror for cause. And I'm allowed to do that. And I assume that it would be presumed, Judge, that in order to challenge a specific jury for cause, I should be able to know who they are. I should be able to know what their name is. I should be able to know some information. Now, I did in detail in this brief point out issues that I have with specific jurors. And again, I'm not going to go into that. But the fact is that in order to adequately do that, I would assume that it'd be presumed that I'm allowed to have that information beforehand, and that it's not something that I have to continue to request. And I draw a parallel between this, Judge. The state is under an obligation to provide me all the discovery, and there'll be some subsequent motions addressing that, but they're under an obligation to provide me the information. I would assume, Judge, they're under the same obligation, at least to make sure that I have a complete record of the grand jury proceedings. And Judge, I don't want to belabor this, but I think I laid it out in my brief, and I'll ask the court to examine that. But the vast majority of the cases that Ms. Blake referenced, Judge, simply addressed sufficiency of evidence. They did not suggest that in no way I could challenge the sufficiency and the qualifications of the grand jury. And Judge, I'm going to rest on my brief. I think it was sufficient for the court to see that, at least from my perspective and Mr. Daybell's perspective, the grand jury that was impaneled was not fair. They were not impartial. And I'd ask the court to strike the grand jury proceedings and dismiss this action, Your Honor.
All right. Thanks for go ahead, Ms. Blake.
Sorry, if I can just clarify, because it was a question raised by the court. I did find the rule. It's Idaho Criminal Rule 6.5 that addresses getting access to the voting sheets. And what I want to clarify is the state would have no problem providing the names that would associate with the numbers. I believe we still have a record of that. The court would have a record of that as well. The problem is, and why that is not provided, is the grand jury proceedings are secret, and there are many rules governing those, and the state is not allowed to provide information regarding those. So the only reason that the state had referenced that a request may be made to the court is either way, whether the court provides that information or whether it comes from the state. It's the state's understanding in looking at the rules governing grand jury proceedings that we can't disclose information without order of the court. I understand Mr. Pryor's point, it's well taken, but I just wanted to clarify this is not a situation where the state is trying to withhold that information by any means, but it would be information that would either need to be provided by the court or that the state would need to be authorized to provide from the state's interpretation of those rules and statutes.
Okay, I appreciate that final clarification. Counsel, I'll consider this matter submitted as to oral argument on that final remaining issue where there's still a follow-up supplemental brief provided for the defense. I am going to order at this hearing that based on Idaho Criminal Rule 6.5 and a request made by the defense that there's an authorization for the voting rolls to be revealed in terms of identifying jurors by name and not only by juror number. So that information will need to be provided, and I'll authorize that. If you would submit an order to that effect, Mr. Pryor, I'll get that signed so that the administrators of the case in Fremont County and the clerks are able to supply that information, which I presume is held there at the courthouse. That'll be the only ruling I'll make on the issue for today. I will indicate that on the supplemental briefing that's being submitted by both sides, given the nature of the secrecy of grand jury proceedings and for the reasons already determined, allowing for the filing of the first brief under seal, I will order that those supplemental briefs also be filed under seal. And if you could each with your brief just submit an appropriate order also indicating that the matter needs to be sealed and citing the information as being secret under the criminal rules as it relates to grand juries, then we will file those under seal, and that will take care of that administrative process as well. So I'll wait to see the remaining briefs and take the matter under advisement. The court will then issue a written decision after it's been fully submitted. Mr. Pryor, anything further on your motion this morning?
Nothing further, Judge. May we have permission to be excused?
Yes, thank you, Mr. Pryor. Ms. Blake, anything further from the state?
Nothing further at this time, Your Honor. Thank you.
All right, counsel, thanks for your preparation this morning and your arguments, and we will be in recess.